Welcome, everybody. I guess Pinny guilted me into standing up, even though I need arthroscopic knee surgery coming up, but okay. The Aleve is kicking in.
If anybody was here at the last session, you're not allowed to be here, so please.
Exactly.
We're repeating ourselves.
Okay, so a couple of housekeeping items. My name is Ronald Spirn. I'm a certified elder law attorney. I'm doing the practice of elder law for 20 years. I work oftentimes with Pinny Heller. Pinny is the, tell me? I have to know, you have to say it. He's the director of Medicaid services at Senior Care out of Brooklyn. And what we're going to be talking about tonight is asset protection planning. Asset protection is a code for getting Medicaid, because what people want to know about very often, I'll get to the question in a second, is how can we shelter our assets or our parents' assets and get the Medicaid services. So that's what this session is going to be focusing on. If anybody has questions, then in the audience is Charles Barron, one of the attorneys in my law firm, and Esty Levinson, one of the other attorneys in my law firm, and they'll give you an index card for you to please write out the question, legibly, hopefully, please, and not that lengthy, and then we'll have about 5 or 7 minutes at the end that Pinny and I will entertain the questions, we'll give responses, and then after we'll be here as well. Is it an urgent question that can't go in a card? Go ahead.
I'm in Connecticut, so I'm just wondering if this is relevant.
Completely different.
So should I just not?
Well, you may be in Connecticut, but I don't know if you have a loved one.
No, my father lives in Connecticut.
Connecticut. Unfortunately, this would not be helpful in any way.
Not in any way.
Right.
Michigan, either.
Michigan, New York. New York, this jurisdiction. Penny, are you doing Michigan or Connecticut Medicaid?
Nope.
I don't even know what kind of programs they have out there, but New York is very generous, so we are fortunately able to help people in this regard. Okay, so what is asset protection planning? Asset protection planning is the process of an individual or individuals setting up some device or some mechanism by which they are able to shelter their assets legally and then get Medicaid benefits. Come in. There's a seat right here, sir. We're going to talk about the interplay between elder law and the Medicaid application process. We're also going to touch upon the differences between advance planning and crisis planning. Unfortunately, far too many of the families that come into my offices are in a crisis already. And like any other situation in life, you have a lot more options available to you when you're more in the driver's seat and you have a little more control, as opposed to already being behind the 8 ball and at a loss, and you're dealing with the health care of a loved one, and now we're also worried about how are we going to pay for it, how are our parents' assets not going to be completely wiped out. So I'm going to just hand these out to you. These are an outline. Esty and Charles, just an outline of what topics and what areas we're going to touch upon this evening. Look, we have 45 minutes with introductions and Q&A for Pinny and I both to present. So we kind of cover a lot of territory. We'll stay at the end for a couple of extra minutes to answer questions before the 8 o'clock keynote speaking session. Okay, 7:06. Very good. The foundation of any asset protection plan, the foundation of any elder law plan must necessarily be the advance directive documents. Advance directives are documents that people complete, that people sign in advance of a crisis situation. So what we want to see, and what I urge clients to avail themselves of all the time, is to set up with a lawyer power of attorney. And a power of attorney is a document that deals with legal and financial decision making. There are different types of powers of attorney, and there are powers of attorney that are available on the internet, on LegalZoom.com. You can Google it. You can go into Staples or some of the legal stationery stores, and you can get a power of attorney form, and chances are it will not be completed properly. It could be witnessed, it could be notarized. When I say properly, I mean that it has the necessary legal provisions contained within that document to give the agent, the person that is named in the power of attorney, the authority to act on your behalf. So, if it's not executed properly, or it doesn't contain the necessary provisions, it's going to be almost worthless for our purposes. Yes, you can go and pay bills with it. Yes, you can go ahead and probably sign a lease or do some other type of legal functions. But when it comes to asset protection, then a cookie cutter standard power of attorney form is woefully insufficient. The power of attorney form itself does not even have the necessary language. And I'm talking about the statutory form, the form that the New York State Legislature has promulgated as being the power of attorney form to be utilized. And in order to make any type of asset transfers or to do asset protection planning with that power of attorney, it has to have what is known as a statutory gifting rider, an SGR. If it doesn't have that, then you can run into serious impediments in order to try to shelter assets. Just like there's a form to make substitute financial or legal decisions, there is also a form to make substitute medical decisions on behalf of another person. And that document is referred to as a healthcare proxy, a medical proxy. And the medical proxy form lists one or more individuals that can make medical decisions on your behalf if you are unable to do so. So as long as a person is competent and they do not lack mental capacity, they make their own decisions. As long as they're able to make sensible decisions, then the doctors will ask the person, what do you want to do? But if it comes to a point where the person has, let's say, dementia, or they're unable, or they're not oriented to time and location because of a medical event or a medication, then the healthcare proxy, the person who's named in the proxy, is the one to make those decisions. Now, in a power of attorney, you can name 1, 2, 3 individuals at one time, all who can act equally on your behalf. Okay? But by a medical proxy, a healthcare proxy, that is not the case. You could only name one individual at a time. So if you have 3 kids named on the power of attorney, all on the same equal level, you could then name all 3 of them, but it will be 1, then 2, then 3. The government doesn't want there to be any type of disagreement or arguments when it comes to medical decision making on behalf of a person, because somebody's life or somebody's well-being could be at stake. if they disagree about what to do with a bank account, or should we cash in a CD to get a higher interest rate, or something else, it's nicht gefährlich so much. Nobody's going to really suffer that greatly. Along with a healthcare proxy is another medical directive called a living will. And a living will is an end-of-life decision-making document wherein which a person can state what their wishes are about artificial nutrition and hydration, respiration, and artificial life support, and whether or not they want it or not. Now, as I said in the first session, I'm not a posek, I'm not a rav, so I don't get too involved in that part of the decision-making as to whether or not a person wants a standard healthcare proxy and living will, or if they want a halachic living will. Speak to your local Orthodox rabbi or whomever, make your own decision, and we will be able to provide you with whatever decision, whichever document it is that you want. Suffice it to say that most people that use the halachic, oftentimes we see the Agudas Yisrael of America form being used. I think one of the sessions tonight, one of the breakout sessions, is addressing that item, and then you name the rabbi, you name whatever, I don't know if it's a yeshiva or a shul, whatever halachic board or authority, it gets named into that form. So that completes the short list of advanced directive documents, whether it be for financial, legal, or medical substitute decision making. Those documents are the foundation of any elder law or asset protection plan, because you can't show up like so many families do in my office and say, okay, we need to get Medicaid because our mother can no longer stay at home and she needs to go into a nursing home, so we're going to contact Pinny at Senior Care and we want to get the Medicaid, but Mom owns a house. She owns a house in Borough Park. Okay? So how do we do that? How do we protect the house? Well, do you have a power of attorney? Do you have a power of attorney with a statutory gifting rider? Or if it predates when the law changed in 2009 and 2010, does it have a gift-giving authority? If it doesn't, and the parent is incapable of formulating or making her own legal decisions, she cannot transfer that property out of her name. And it will therefore potentially be an impediment to her Medicaid eligibility. If it's not a house, it could be a bank account. If it's a CD or a savings account and it's got $50,000 in it, Penny will discuss some of the numbers. She's over the limit. How are you going to walk into a bank and look at the teller and say, oh, I want to transfer $45,000 out of my mom's account? We'll call the security guard and escort you out right away. So if you don't have the proper legal credentials and you don't have the proper legal authority, you're not going to be able to really implement a full plan. So that covers the advanced directives, partially. Let's say we're doing an advanced plan, and it's not a crisis plan. And a husband and wife come in, and they're both in their late 70s, and they own a house, and they have a couple of $100,000 in the bank that they saved all the years, and it's getting shvachamitis, and they need Medicaid for the mom, for the wife. She can't really ambulate anymore. She can't fully function. She needs assistance with her activities of daily living. They want to get Medicaid. Okay, so they're doing advanced planning. It's not really a crisis where somebody's like going into a nursing home already and we're behind the eight ball. They want to do advanced planning. So we would advise that couple to take their house and their money and set it up in an asset protection trust that would be in their name. So if Chaim and Chana Goldberg come in, will set up the Goldberg Family Trust or the Chaim Goldberg Family Trust. And the trust is an agreement. It's an instrument that says what is to occur and how my assets are going to be protected. Because you can't just do any old trust. It has to be, number one, irrevocable. If it's revocable, it's not going to provide any asset protection relief. So it has to be irrevocable. And there are lots of different kinds of irrevocable trusts. People set up irrevocable life insurance trusts. People set up other type of irrevocable trusts for doing estate tax planning. That's not this discussion. We're talking about an irrevocable trust so that when a person goes to Pinny and says, okay, we want to get Medicaid, we look and say, okay, it's an irrevocable trust, so that means that Medicaid is going to qualify you because it's not something that you could schlep in and schlep out on a moment's notice. It has to be sheltered legally. So the irrevocable trust is set up by one of the parents, and into that trust goes a house. How is a house magically transformed into a trust? It's not magic, obviously. We have to do all the deed transfer papers. If it's in New York City, we have to do a deed transfer. We have to do different type of New York City transfer tax forms. Same thing in Nassau County or in Muncie. It's all part of the process to make sure that the title of the property is now put into the trust. Once it's in the trust, then the benefits shall accrue. A bank account or a brokerage account. Also, we go into the bank, and if your parent is not well enough, hey, now you have the power of attorney to go ahead and to make that transfer of the brokerage account. You don't have a power of attorney, they're going to show you the front door. So you have the power of attorney, assuming the parent can't make it in themselves. And look, I've signed as many powers of attorneys in hospitals, in nursing home settings, in assisted living facilities than in my office. So it's something that is extremely common because it's very, very necessary. So you take the power of attorney, you say, here's the trust. We did it with the lawyer, and you have the tax ID number, and we go into the bank or the brokerage, and you are able to then conduct your business and transfer the assets that are in need of protection into the trust. What do I mean in need of protection? Well, not all assets need to go into a trust. Well, not all assets need to be removed from the Medicaid applicant's name. For example, an IRA. An IRA should not be closed out and transferred into a trust because, as Penny will tell you, IRAs are exempt. So IRAs, as to the principal, the corpus, the balance of the IRA is exempt from Medicaid. As to the distributions, that's a different discussion. Penny will touch upon that perhaps in his portion, but not all assets go into the trust. But that's where sitting down with a competent advisor, an attorney, a legal advisor, can guide you and direct you as to which assets go into the trust. Who manages the trust? You have a trustee. You could have co-trustees. Typically, parents name a child or children. And I tell people all the time, please, only name a trustee that is trustworthy, is well-balanced, doesn't have any type of issues going on, because you want that trustee to be able to properly administer the trust. You know, many years ago, like 15, 20 years ago, it was much more common for attorneys, for Eldercare attorneys, to tell clients, okay, you can put the assets into your children's names. That's really a terrible idea, because when you transfer a house or a brokerage account into a child's name, guess who now owns that house or that account? And even if they're the most trustworthy a person in the world. It's not about lack of trustworthiness. But what happens if that child passes away before a parent? It's happened. Gets divorced, becomes disabled themselves, goes bankrupt, is in a car accident, is in a lawsuit. Now the parent's asset in the child's name is going to be very exposed to the child's problems, legal and otherwise. So we don't want that should occur. The very safe alternative is to create and establish the irrevocable trust. And by putting it into the irrevocable trust, you're able to make sure that the assets are sheltered. The last item that I just want to touch upon very briefly before turning over the floor to Pinny is about last wills and testament. So, a will does absolutely zero when it comes to protecting assets during the person's lifetime. A last will and testament only is activated when the person passes on. So after they're gone, that's when the provisions of the last will and testament kick in. But during lifetime, a person should have a will regardless, even if you go ahead and pursue the asset protection trust concept or some other method of sheltering your assets in order to facilitate getting Medicaid benefits. Because the person may have another asset, it's not in a trust, or that they didn't transfer to the child, and we don't want to have a type of situation, if it can be avoided, where there's no will. It could lead to squabbles among family members. Who should be the administrator when there's no will? That's called an intestacy. And you have to go to surrogate's court, and you institute an estate administration proceeding to be differentiated from a probate proceeding, which is when a person has a will. It nominates an executor. It says who should inherit the estate. If there's a special needs family member, the will can, as well as a trust, provide for that special needs family member. So to round out the elder law portion, we don't want to ignore any aspect of it. To complement the advance directives and the living trust should also be a last will and testament. Penny?
Okay, ready. How many people here are here for somebody who already has Medicaid? Okay, so I'll leave out that portion. There's just something major going on. You'll see it all over the buses, street signs. It's something called FIDA, F-I-D-A. If you are not here for someone already on Medicaid, don't need to even worry about it. Just to take out your pens, your pads, write down these two numbers. 845. That's not how long I'm going to talk to. 845 and 14,850. 14,850. So the 845 is Medicaid's brand new 2015 number for the amount of income that an individual is entitled to have under Medicaid. $845 a month. If you have if you or your loved one has more than that, we'll talk about that in a second. But that's the threshold, Medicaid threshold. Another Medicaid threshold. I'm sorry, single individual.
What's the other?
Another number is $14,850. That's the amount of assets that a single individual can still have in their local checking, savings, CD, and still be on Medicaid. That, of course, excludes any IRAs, pensions, 401ks, POs, any kind of retirement plan.
Social Security?
Income. That's income.
That's income.
$845. Right. So very important, those two numbers. We start with those two numbers. Now, let me talk about one of the some of the biggest misinformations out there. One is that if your income is above $845, you don't qualify and you should be leaving now. That's a big misinformation. Income is never a technical disqualifier. It's what I refer to as a practical disqualifier sometimes. By that I mean, if your parents' income is $10,000 a month between their Social Security and their pension and their rental incomes and anything else that they may own, investment properties and all kinds of things, then chances are they can probably pay for their home care on their own. And you probably shouldn't do what's necessary to get them on Medicaid. Because reportable income is anyway, you're going to be way above. However, it's not a technical disqualifier because if they're only over by a small amount where you actually need the income, then you can set up something called a pooled income trust to be able to retain all the income and use it for their living expenses. The way to kind of figure this out is very simple. Is my parent living on their income, or are they saving thousands and thousands of dollars every month going away in their savings account? That's the barometer. But keep in mind, income is never a disqualifier. Assets is. So if their asset base is above $14,850, something needs to be done. And that's what we're here to discuss today. Transferring the assets. Again, I want to reiterate because this is something that so many people make a mistake on. And I see the aggravation when they come to the office and they say that they liquidated IRAs. IRAs are completely taxable. You'll pay Uncle Sam a tremendous amount of money to liquidate an IRA. And there's no need for it as far as Medicaid is concerned. All you need to do is make sure that there are proper designated beneficiaries on the IRAs so that whoever the parent wants to inherit that IRA money will inherit it, and the beneficiaries are listed. Just call the bank, call the broker, ask them who's listed as beneficiary. The one person that should not be listed as beneficiary is the spouse. So if you're lucky enough to have both parents, usually if they both have IRAs, I promise you, in most cases, your mother will be the beneficiary and your father's, and vice versa. That should be changed. And all it is, it's free. All you got to do is call up, get what's called a change of beneficiary form, fill it out, have your parent agree to it, and it's done. The principal, as Ron mentioned, is an exempt resource. It's not party accountable resources. So you could have $1 million in your IRA, and it's not a countable resource. And you could just leave it alone, and it could just be inherited after 120. Practically speaking, though, with a large IRA like that, chances are that the required distribution that the IRS mandates that you take every year will be very, very high. So let's take a practical example. Somebody has, and we're talking about parents, of course, somebody has an IRA that has $150,000 in it. The distribution is usually, again, I'm not an IRS expert, you can look this up online, but usually it's approximately 4%. So on $150,000, what are we talking? $5,000 annually. You divide that by 12, you come up with $450. That's their monthly income. That's the way Medicaid would calculate. You add that to any other reportable income, Social Security, pension, and that becomes, voila, their monthly Medicaid income. So suppose the monthly Medicaid income, after you calculate all of this, comes out to $2,845. That means that they're exactly $2,000 over the $845. That's where these pooled income trusts come in, and they're so valuable. The pooled income trust is basically like a certified gemach, where you can actually, after your parent's income gets direct deposited, as it usually is, into their local checking account, after that, that stays, so you don't mess with the Social Security direct deposit, you don't mess with the pension direct deposit, you leave that all alone. The IRA distribution is probably set up from years ago to go straight to their checking account, leave that all alone. After the income goes in, you take the excess, which in this fictitious example, $2,000, and you transfer, you write a check, or automatically have it transferred to a pooled income trust account set up in the name of your parent. So John Doe sets up an account with a certified pool trust, and every month they deposit their $2,000 in there. The benefit of doing that is because that $2,000 is now available to use for any and all living expenses. The odd thing with Medicaid, the odd thing is that the $845 stays in the account, and Medicaid doesn't really care what you do with it. You can leave it there. But the only thing you have to show is that the $2,000 of the excess income is being used for monthly living expenses. And what we try to do in our office, and you can actually do this on your own, you don't need any fancy schmancy representative, you can do this on your own, is figure out your parents' expenses. The big ones that we usually use, rent is a big one. If they own a home, or if they were smart enough to transfer the home, usually the parent has the right to live in the home. That gives them also the responsibility, the achiezer of paying all of the income for the house, the expenses. For example, property tax. For example, gas, electric, anything on the house. So once you figure out their expenses on the house or the rent, another big whopper we always say, set them up, make sure that they have an active credit card. Throw all the grocery shopping on the credit card. Don't pay for cash. Use the credit card. You'd be surprised how quickly you're going to generate a substantial bill on the credit card. That credit card should not get paid from their checking account. You give the bill at the end of the month to the foundation. They will pay the bills. The idea is to try your best every month to exhaust the income that you put in there. You put $2,000 into the piggy bank. You want to make sure pretty much on a month-to-month basis that it's getting down to zero and you're using it up every month. If you don't be horrified, the money will stay in there. It'll roll to the next month and you can use it the next month. But remember, the next month you got to deposit another $2,000 in there. So you want to try your best to make sure that a balance doesn't accrue in that full trust, because the only time you actually lose the money is only after 120. After 120, you cannot pay for anything, even a funeral. They will not allow you to use it. It's frozen and the foundation gets to keep the money. So the idea is to try your best to set it up in such a way where it's being used up every month. That's the bull trust. I want to go over some of the other misconceptions about Medicaid. With Medicaid, I find that there's way more misinformation than actual information. So one of the biggest pieces is the income. That's a big one. Another big one. My father has a house. He doesn't qualify. That's a huge mistake. There are so many things. First of all, technically, a primary residence is exempt. A primary residence where they're living is exempt. Now, I nor any responsible representative or advocate will never tell you to leave the house in their name. But technically, you can actually qualify with the house. I would strongly advocate for you to go to someone good like Ron that will tell you what the smart thing to do is, whether it's transferring to the kids, with a life estate, whether it's putting it in a irrevocable Medicaid protection trust, anything like that, an LLC, depending on your personal situation. But technically, the house is exempt. So that's a big misconception. Another one. People say, even if I go to a lawyer and I do the right thing, they're going to come after me after my parent is not here anymore. They're going to come after us. That is true, except if you go to someone responsible that's going to do the right thing. The goal of anybody like myself or Ron is to recommend and to advise how you can make sure that there is no estate created after 120. That's the goal, in a word. That's the goal. The fancy lawyer word would be, make sure there's no probate estate. But for the average person, make sure there's nothing left over that after 120 will fall into their estate. That's what Medicaid relies on. The silliness of people to do the wrong thing. And believe me, for every person that does the right thing, there's 5 of them that do the wrong thing. And there's always an estate left over. Medicaid almost always gets paid back. And that's why that reputation is out there. People say, don't go to Medicaid because they'll just come after you later. Because there are so many people making mistakes. Another big one, this is a huge one. Everybody says, isn't there a 5-year look back? I heard about this 5-year thing. Well, it's true there is a 5-year look back, but it's only if someone unfortunately needs to apply for nursing home Medicaid. Not for what we call community Medicaid. Community Medicaid is when someone's receiving benefits at home. Now, at home could be their own apartment, their own house, or an assisted living. Assisted living is considered, it's under the community umbrella. You could actually, if you could afford it, you could actually send your parent to an assisted living that's suitable, privately pay the room and board, but have the home care covered by Medicaid. Sometimes the home care is just as much as the room and board, sometimes more, depending on how many hours of care they need. That's a huge piece to understand. There's a chilek between community Medicaid and nursing home Medicaid. Nursing home Medicaid, 5-year look back. Community Medicaid, in New York City, no look back. In Nassau County, Westchester, Suffolk, 3 months. 3 months.
Jersey.
I don't know Jersey. You're in the wrong room. But you can technically, in New York City, you can technically transfer your parents' assets tomorrow and qualify New Year's on Thursday. In Nassau County, you'd wait till around Pesach time.
And a New York resident has to stay in New York?
For community Medicaid, yeah. New York State's not going to pay for you to go live in Florida.
There are Medicaids that accept this.
Well, they're going to pass around cards. I just want to get to a few things because there's mamish no time left. Another big one that's a one that you should understand. A very, very big mistake people make. They'll go to an attorney. They'll spend the money on the attorney. The attorney will set up the beautiful trust that's excellent, worded exactly the way the parent wants it. But based on the parent's resistance to giving up control, they will not fund the trust. Nothing will go in there. You pay the bank for a safe deposit box, and you put nothing in there. That's kind of what happens. There are so many people who come to my office and say, I shouldn't have a problem. My father told me he spent a lot of money on an attorney, and he set up a trust. Everything is taken care of. I go to the website, I check the deed, I say, give me your parents' address, I look up the deed, it's in their name. The father never wanted to do it. Another big whopper mistake people make. They'll send a parent to an attorney. The parent will basically tell the attorney, like Ron, I don't want to give up control. So they will say, you know what, for you, maybe a revocable trust would be the right thing. For Medicaid, revocable trust has its advantages. For Medicaid, it's useless. Useless. I had someone that transferred $20 million in 1994 to a trust. He said, we're all good for Medicaid. Please put my father on. I took a look at the trust. It says revocable. He says, impossible. The attorney charged a fortune. He wouldn't have done that. Revocable trust. It was meaningless, useless. They were going crazy. These are the kinds of things you have to stay on top of. It's so easy to say, oh, we can do A, B, C, D. Make sure you go to someone competent. I said it before, I'll say it again. It has nothing to do with me or Ron. Do you know somebody who does Medicaid? Do you know someone who does legal elder law? Fine. Use them. Make sure they know Medicaid well. Make sure they know estate collection well. You don't want to go to somebody just because they're a friend and you save a few dollars and you risk the entire estate. I've seen it happen just about every single day. It's a big, big mistake. In conclusion, I just want to say just a couple of things. Ron mentioned this. I can only reiterate it 1,000,000 times over. I've seen the pain from people coming into the office where they have a parent, unfortunately, in a hospital, on full-blown dementia, Nebuch on a stroke, on a vent, and they can't touch the assets because they never even got the power of attorney. I beg you, go get the power of attorney. Don't save the few $100s. Go to an attorney that's competent and will draft up the proper powers of attorney. They're worth their weight in gold. You must have the proper power of attorney. The other thing I say to you is, it's mamash and inyan or kibbut avein. I'm telling you, talk to your parents. Don't take no for an answer. I'm telling you, the one thing your father and mother want, they don't want their hard-earned money going to a nursing home or going to the state. They want you to do the right things. All you need to do is be able to convince them and say these magic words. Nothing will change. You will not lose control. It's just moving stuff around. You will have all the control you always have. If you bring them to me, I will convince them to do it. I will convince them. It is critical. All you got to do is tell them about the alternative. And the alternative is so much worse. That's a very, very important thing. Okay, I guess we're up to questions.
Questions and answers. Okay, I hope we have some good answers. There you go. Okay. Can a person with dementia sign a power of attorney? Well, that's a difficult question to answer because it depends upon how the person's capacity is. I mean, are they familiar with their surroundings? Are they oriented to time and location? Attorneys are not neurologists, but we would sometimes ask a neurologist for a letter or a doctor's letter saying that the person does have the ability to sign legal documents. How is the money in an irrevocable trust allowed to be spent? What happens to the money in the trust after 120? So the way that the money in an irrevocable trust is allowed to be spent is only going to be as a result of how the attorney drafts the trust. If the trust is just a one-way ticket and there are no provisions put in there by the attorney who drafts the trust document that allow the child or the trustee to withdraw money, then the money is just going to be stuck there. It is therefore critical that the documents contain the necessary provisions to enable someone to do that. What happens to the money in the trust after the person passes away is that the trust is like a will substitute. The trust will state who inherits the assets. It could be my kids, it could be Hatzalah, it could be all of the above, it could be whatever the person wants, that would get put into the trust. So it's the attorney's job, one of the attorney's functions is to find out who gets the estate when the person passes. Okay. What are current estate tax laws? We're not going to get into that now because it's not part of this discussion, but after you can speak to Charles. Charles is an estate tax specialist. Okay. If a primary residence is transferred to a Medicaid trust, is it best for the parents to be required to pay rent to stay in the home? Perhaps. It's an interesting approach. We see all different types of methods and procedures that people, so it can come into play that if that makes sense, and then the pooled income trust can go ahead and cover those expenses.
I would just add that, whoever asked that question, I would add that if the income is very high, if their income is very high, and you want to have somewhere to be able to exhaust that income, that's the way to do it. And most one-family homes, you could charge a large amount of rent easily, depending on the location.
Ron?
Yes.
Question about the revocable trust.
Yes, ma'am.
Appoint the trustee. So technically, the ones who form the trust, which are the parents, you really don't have any control anymore at that point.
Not correct, because again, it all comes down to the drafting. If the attorney knows his or her P's and Q's, you can absolutely put in a provision with the right to remove and replace a trustee upon 3 days written notice.
But they can't take it back. They could replace the trustee, but technically they can't take it back whatever was put into the trust.
So that's a different issue, that's a different question, and that's correct. It's an irrevocable trust. Charles, you're screening all of these before you give them to me, right? Good man. Are there special provisions for Holocaust survivors who never received reparations? Whoever had that question, you could ask me that after. There are special provisions, Pinny Holocaust reparations monies in the context of Medicaid.
Well, they're saying they never got it. If they never got reparations, there's nothing you could do. If you did get reparations, keep in mind, this is a big one, with German reparations, people have this tendency, especially the parents, they'll always say, don't tell them about it. They'll always say that. Keep in mind, anybody who's been receiving German reparations, whether it's the monthly Wiedergutmachung, whether it's the quarterly Claims Conference Article 2 money, it's a tremendous benefit for Medicaid because you're entitled to keep potentially well over $100,000 in the parent's name. It's a big, big benefit. So it's very important to know about it.
That's for you.
Okay, what if
Well spouse has assets and Medicaid candidate
Okay,
doesn't?
so that gets into the issue of spousal refusal. That's a whole discussion. But keep in mind that if somebody, it's a very important one, just not enough time to discuss it all. If chas v'shalom, one of your parents needs to go to a nursing home, and within the 5 years, assets were transferred, or they never transferred assets. If there's Baruch Hashem a spouse, a community spouse, you can always get Medicaid. Always. With the spousal refusal. Always get Medicaid with the spousal refusal. However, there are ramifications to the spousal refusal that you need to know. Not for now, but there are ramifications. If someone is heading to a nursing home, and there's a spouse at home, Medicaid is the way to go for a variety of reasons. That's the way to go with the spousal refusal. But there are ramifications to it that you just need to know on a case-by-case basis.
There are nursing homes that accept that.
Everyone.
They have to, sure.
Not assisted living.
Yeah.
That's not a nursing home.
It's not free, the government is paying. Okay, whoever had the estate tax question, ask Charles. Whoever had the question about the trust and the mortgage on the house, go to Charles. Okay, we have to let everybody go and wrap up. It's 7:46. 8 o'clock is the keynote address back downstairs in the main ballroom area. Penny, are you going to stay a couple minutes? We'll be here for a few more minutes to answer some questions.